a gift, but if you would like to, I appreciate it. All that good stuff, so that way they don't come over and ding me while I'm doing this, so I can get through this, okay? I'm gonna have my head down during the most of it. Let me wet my whistle. Okay, so let's see what this is. Respondent's Trial Brief, RE First Amendment Rules. So this is Bree's attorney's response to the amendment rules that they put. Summary effects. Why do I want to read it in such a dramatic tone? This is not a case about any actual domestic violence, DV. But it is about a spiteful ex's desire to use a child to control his ex and continue harassing and abusing her. This case involves an extreme amount of litigation abuse, all perpetuated at an opportune time. Starting with the service of this case on W's mom, respondent Brianna, when she was just 5 days postpartum, after Dad's, petitioner / John, absence the entire pregnancy and becoming heavy during the 12/24 to 4/25 period when W's mom was self-represented. Under California law, an established First Amendment precedent, a parent's online opinion about the other parent are generally considered constitutionally protected speech. She working hard trying to cover her eyes. As a result, court faces significant constitutional limits when attempting to resist this type of content. Typically, criticism, negative commentary, exaggerated statements, and purely subjective statements, as a few examples of many, are considered protected types of speech online between parents online. Conversely, defamatory allegations, proverbially false statements, and threatening or harassing speech can be restricted. Ironically, it was John who took the private Discord channel to incite violence on Brianna amongst his supporters while this case has been pending. It was John who planted the hugest defamatory statement of them all online during the pendency of this case that Brianna kidnapped baby W, which he based on the non-existent non-served order. Despite the court's order on the 3/17/25 RFO hearing, a hearing Brianna did not attend, his attorney filed the order in the same e-filing envelope that the ex parte kidnapping RFO was filed within. In other words, there was no signed order in place under which this type of allegation could be based, let alone one properly served on Brianna. And the arguments made in that motion do not even remotely meet an element of kidnapping under California Penal Code. Nevertheless, John persisted with his narrative and still does in this present day, convincing the court of public opinions online that Brianna kidnapped her own child. Brianna has been torn apart online as a result. Did we miss that part? Has anyone seen that part? No? Just curious. Keep reading. Anyways. So she's been torn apart online as a result. And her mental health and livelihood greatly affected by this harassment and untruthful narrative. Doesn't she always say, F you, you guys can't hurt me. I don't give a fuck what you say because I know what I'm doing. You guys aren't going to bring me down. Da, 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 da. Now, granted, her people oftentimes will say that if they want to say that, but I grasp that her attorney has nothing to go on. I grasp that. And so I know that at this point, she is reaching for anything she absolutely positively can. She is going to reach for in hopes to get something. That is a great question, so yeah. She was supposed to. It was in the order. She was supposed to go get some type of therapy. So, yeah, she does joke often about. Court trial starts August 22nd. Okay. Let me go back into reading. Within the first 3 weeks of W's life, John had already served Brianna with a case on 5/1/24. His first request for a DVRO, all denied. On 5/3 and reverse moveway order, RFO, on 5/7. All while Brianna had no lawyer and was trying to navigate the first month caring for a newborn, mostly alone, as a first-time parent. I'm so tempted to flip over to the videos, but I'm just going to keep reading. John has never had any interest in co-parenting or even having Brianna in W's life. Once John obtained temporary sole custody of W in 3/25, he pawned the toddler off on his mom at his mom's house and lived separately from W in his own apartment. This lady. It is not just John's desire for control that drives this case, but his need for the public's attention, both to make his money and because he thrives on being relevant online. This bitch. This case involves numerous publicity stunts, such as filing an ex parte RFO for kidnapping on 3/24/25, absent parent service of the court order of 3/17/25, under which the kidnapping allegations were based. Brianna was not represented on 3/17, nor did she attend the hearing. That's all her problem, right? Can her lawyer get in trouble for all these lies? They'll just go back forth at it. They won't be of record. Right. She didn't show up. She chose not to. She knew she had it. She said herself she had better things to do. She just didn't feel like going. It's whatever. She also they tried to serve her in her case. She didn't have it. But then right before she did nap the child, she sat there and read the entire order that she was not allowed to take him out of Dallas County. She read the entire thing. Now, I do grasp that you have to be served the proper way. That's just what it is. You have to be served the proper way. Oversleep. She really just didn't. She said that she never planned on going. Yeah, she even had an email from her attorney. She called a friend. Anyway, she was a mess. She knew. She just chose not to because Bree is not one that gets told no often. So she always thinks she can get away with it. Yes, Amanda. And she's like, question. She's been over it for a long time. Can they use the word abduction? I don't think so. I don't think they're going to... I'm not sure how they're going to utilize it or word it. Because technically she was not served properly. But then the whole canoodle of her getting served, she did get served properly to return the child and she chose not to. And then to have a 2.5 hour standoff with the police, that's where you can get in trouble. Oops, hold on. Oh my gosh, I hate this. Okay, hold on. I hate when comments that are big get pinned. I can't read the whole thing. If she was signed up to be... Now I gotta find it again. Okay, if she was signed to be served up electronically, wasn't that email... Well, she wasn't signed up to be served electronically. That's what they're saying. They're saying she was at one point, and then when that attorney left, she didn't re-sign up to be signed electronically. So that was the loophole in it. She had to re-sign up stating, now I'm fine to be served electronically. So that's why. And even though she read it, it doesn't matter. You're right. It is stupid. She read it. She knew she had it. She knew she missed the court. But they have to go by the court the way the court rules are. Okay, let me keep reading because this is a long one. I don't know where I left off, so I'm going to start with here. This case involves numerous publicity stunts, such as filing an ex parte RFO for kidnapping on 3/24/25, absent parent service of the court order on 3/17/25, under which kidnapping allegations were based. Brianna was not represented on 3/17, nor did she attend that hearing. It was not just service that was missing, but the entire order itself did not exist, as the court had ordered John's attorney to file the order, but she had not done so. The case law is clear. When the minute order directs a separate order to be filed, the latter constitutes the order of the court, not the minute order. In that case, not even the minute order had been properly served to Brianna. Despite full knowledge of all of the procedural background, John and his attorney still wrote the RFO in an extremely inflammatory way, calling Brianna a kidnapper, and John had fueled this publicity stunt online through the present day. Of course, he has not once commented on the legal problems just described, but continues to tell his followers that Bree kidnapped W. First of all, ma'am, all due respect, ma'am attorney, you should probably watch some of your clients' stuff, with all due respect, because she actually thinks it's quite funny, and she talks about doing it all of the time. Matter of fact, that day that she took baby W from Texas to California, she knew she wasn't supposed to. Matter of fact, she knew she was online and she was reading the file. I grasp she was not served correctly. I'm going to give you that, right? But she read it. Then she went on to contact other attorneys to find out what to do. But then she had it planned out before she even left. She had an entire plan. And it got blown up because Stella said something about her coming, and that's when everything on the internet went crazy about baby W coming back here. So stop blaming everything on John. And John has every right to be concerned for his child. Because, ma'am, this is not the first but the second time she's done this. She also, just 2 months before then, when baby W was not supposed to fly, John was in Texas with baby W. He flew baby W to California to be with his mom. Without her even saying a word, she just takes the baby, turns around, goes and books her flight, and flies right back to Texas, says nothing to him. They spend their time out there, he gets sicker and sicker and sicker and sicker. Then gets him back on an airplane from Texas. Instead of contacting John and saying, hey, I'm in Texas, John could have just flown home and he could have avoided 2 more trips. But no, let's not do that. So you can't tell me she doesn't know she's not doing something wrong and she's not putting W first. So instead, she puts baby W back on an airplane, all the way back to California, meets John at the airport. John gets right back and thinks, that baby flew 17 hours. As a couple-month-old. Wasn't even 1 year old. That's disgusting. That is disgusting and selfish behavior. That is about that was a me. Everything's about me moment. Because I guarantee you, had you reached out to John and said, you know what? I really want to do visitation with my family in Texas. You think he wouldn't have taken the opportunity to not fly him out there? He hasn't been wanting Winter or W to be doing all of that flying anyways. So it hasn't been John that's been, being demanding of how things are going to be and pushing and whatnot. It's been Bree. But nonetheless, we'll just keep reading. Thank you guys for continuing to tap. The daily heart me is doing everything you guys can so we don't get flagged. I'll try to get through this as soon as possible. Okay. The case law is clear. When the minute orders direct separates order to be filed, the latter constitute the order of the court, not the minute order. In this case, not even the minute order had been properly served on Brianna. Despite full knowledge of any of the procedural background, John had his attorney still wrote the RFO in an extremely inflammatory way, calling Brianna a kidnapper, and John had fueled this publicity stunt online through the present day. Of course, he has not once commented on the legal problem just described, but continues to tell the followers Brianna kidnapped W. Actually, twice if you want to be clear. My words, not his. But nonetheless, you go ahead. The evidence at trial will show that leading up to the napping allegations, John sent Brianna one Our Family Wizard message. That's the app that they use through the court to keep track. To ask how Winter was, how baby W was, and called the police once for a welfare check. Any parent who believes his child has been kidnapped would certainly have done far more than this. John's concern about the kidnapping was lacking because he, his mom, and his close friends were busy pushing the false kidnapping narrative online for days prior to the filing. This chick is nuts. Wow. That is not how it happened at all, ma'am. You need to sit down. You need to have several seats and you need to sit and watch this stuff. Absolutely. You need to sit and watch the pure panic and fear on John's face and how John has actual friends, real friends that are good, that jumped to help him out and be there for him. John was sick, physically sick about this, knowing that his son is sitting up on this pedestal with all of these lights with TTS stuff blowing around him with all these P3DOs, just shouting out comments at him. The baby's crying, he's going crazy. She takes off in the middle of the night. The only instruction that she gets is just don't let him fall off bed. He should be all right. Are you shitting me? No notice. Packed a bag, jumped on a plane, flew across the country. We're there for you, John. We're there for you, baby W. We're there for you, Mama 2K. No questions asked. And they're like swimwear. Oh, I can't wait for all this to come out. This is getting me heated. Okay. The parties dated for 12 months on and off. John was willingly not present for Brianna's entire pregnancy. Brianna weathered the pregnancy alone in LA, where she lived for 7 years, while John lived between Florida and Texas, and spent much of the pregnancy out partying. So did your client, ma'am. Your client also made movies, and anyways, I won't go into that. It made plenty of money while she was 8.5 months pregnant, but best-selling video that she has, but don't ask me. Okay. Early in the pregnancy, Brianna had to visit the ER due to bleeding and a suspected miscarriage. When she texted John from the ER, his response was, "What is this? Bro, stop texting me. Seriously, you're harassing me. Don't text me anymore." After the doctor cleared Brianna's miscarriage concern and confirmed she had an infection. Shocking. We need a low battery. My thing is plugged in. Okay, hold on. I gotta check my charger again. Let me check my charger because my thing's about to die, but I have it, the right one. I think I have the right one plugged in. Hold on. I'm on Struggle Bus Express. Hold on. Oh my god, the whole damn thing fell out. Good lord. Okay. almost knocked you guys over. Okay, here we go. Right, we know what she does in Coachella. But it don't count. Okay, where was I at? Okay. You harass me, don't text anymore. After the doctor cleared Brianna's miscarriage concerns and confirmed she just had an infection, she texted John the news, and his response was, "Do not talk to me ever again." Throughout the entire pregnancy, John and his mom took to the internet to harass and ridicule Brianna daily. John's social media following was nothing compared to Brianna's. Lady, you just messed up your whole statement right there. You literally just shot yourself in the foot with that statement. Let me reread that again. Throughout her entire pregnancy, John and his mom took to the internet to harass and ridicule her daily. John's social media following was nothing compared to her. So then there wouldn't have been a big response, because you see what had actually happened is John stayed quiet the entire time. She utilized her entire pregnancy bashing John, claiming DV, he left her, everything. When John finally made a, literally, Janelle, it's comical. When John finally made a statement back, so many people hated him. They disliked because they believed that, because he never wanted to speak up. She did have millions of followers. He didn't. He never spoke up because he didn't want to talk bad about her. To this day, he doesn't talk bad about her. He defends her to this day. But when he finally did speak up, after the court, their first court thing, he finally spoke up. That's when people finally got to hear his side. Because when you only hear one side, what do you believe? You only believe what you've been told, right? So when they finally got to hear from John, when like September, October, that is when things shifted. When we finally started to see the truth. All these videos coming out of her completely hammered, unable to take care of the newborn. The newborn just laying down on a booth, unattended. Well, she's on and on and on and on and on. All those videos and pictures, I'm sure, will come to play. So no, Miss Bree is not no innocent party in this. Bree has said herself, this is not something what she wants to do. She's also said herself, she plays in the snow, but only while he's sleeping. Babies, wake up. Anyways. Okay, okay. John's social media following was nothing compared to Brianna's when the two met. And the focus of his presence online was his work in a barber shop. Once Brianna fell pregnant, his entire existence online shifted from being a barber to making it his mission to tear Brianna down. Oh, this is so false. Oh my God, this is irritating to read, because now it's just blatant fucking lies. But this is obviously, right, because this is Brianna's story. This is what Brianna's telling the attorney, so she believes it. But it's all lies. It is lies. John continued to be a barber for a while, but then Brianna kept calling him over and over and over and over and over and over, and telling him he's not going to be anything. You're not going to be nothing. That's all you're going to be, is just a little bitch ass barber. Blah 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 blah. It got to the point, even though he loves being a barber so much, he stopped wanting to do it because it was causing so much havoc at work. And his friend who owned the shop was having to tell him, you have to stay off the phone, and she's blowing him up and talking shit about him for just being a barber. But yet, haven't you gone through now, Bree? Bree, hello. I know you listen. How many TikTok barbers have you ran through since then? Just curious. 3 or 4, if I remember correctly. Just curious. Anyways, I'll keep reading. His mission to tear Brianna down with the help of his mom and friends, who regularly posted disgusting things about Brianna just like he did. I ain't never seen Mama 2K post nothing. Oh, my life, no, that's okay. This, don't talk about Mama 2K now. I'm gonna have to hurt you. John has not posted any barbershop content in over a year. What does that have to do with the custody case, ma'am? What does that have to do with a custody case? Even though I just saw him at barbershop, I think like last week or so. I don't know. With none in Texas. No, Tennessee. No. Let me see. Instead, John's entire platform is the drama that surrounds his case and his testimony at the 10/30/24 DVR trial on his first, all denied, request for a DVR confirmed. This case is how he makes his money. Hold on. Doesn't this lawyer have to prove? Yeah, she does. The comeback from John's attorney on this is going to be priceless. Just make sure you guys just keep tapping Daily Heart, whatever, commenting, do whatever you can do just to keep that active, and then so they don't come for me because we still got a ways to go. How he makes his living. Brianna's prior attorney asked John if he posted content of himself the last time he was in court, and the answer was yes. John then went to explain, well, when I was getting canceled and there was no peace in my life, I wasn't making any money. And now that people see I am a good dad, I'm making a lot of money. What would the problem with that statement be? Well, I just don't understand the serious question. Why does Santos crash out every time? I don't know. We'll have to discuss about that afterwards. He later, I think you meant open, that his content is barber content, dad content, and family-friendly community content. If anyone spends 5 minutes on John's TikTok or Snapchat accounts, it is painfully obvious that was false testimony. No, I don't believe that. John only says and posts hateful and harassing things about Brianna and talks about this case with sprinkles of photos and videos of W. At least 90% of his platform is anti-Brianna hate speech and chatter about this case. This bitch is delusional. What the hell is she talking about? She's crazy. Has she even looked? This is so beyond infuriating. Because no part of it is that. If anything, he answers questions. And when people bring it up, he bashes them. He protects her. Right? I don't know. Oh my God, that's so frustrating. The other 10% is photo and videos of Winter violating his repeat requests made throughout the case that W not be posted online. John repeatedly posts W online and allows random third parties who have no relationship to the family to do the same. Wrong. While denying Brianna the opportunity to take a single picture or photo of Winter for the last 4 months at her supervised visitation. Again, that was stated in court. That's not up to him. He says, yes, the supervised visitation center, ma'am, that you guys chose. John and his attorney did not choose this place. You did. Their rule. It says in there, she picks the days and times that her and John agree upon, and she also has to follow all of the rules of the visitation center. The rule of the visitation center that you chose, ma'am, says no pictures, no videos, no phone, nothing. Zip. So that's not on John. John has said several times, please give her those pictures. He sends her pictures himself. Wrong. Ooh, I want to be in the courtroom now. Okay. This is just one of many ways that will be illustrated at trial in which John continues to try to control Brianna. Per the professional monitor's rules, no video or photos are allowed unless by written agreement of the parties or court order. Brianna has repeatedly asked John for permission, and Miss F has asked the same from his attorney, to take photos and videos of W for her own personal use, not to be posted like during Mother's Day visit when she had her mom and W all in one place. A very rare sight since her mom lives in Texas and she lives in California. The answer from John and his attorney has always been no, in response to repeat requests made for 4 months. John then takes to the internet to lie about the numerous times he claims he is just abiding by the monitor's rules, leaving out the fact that the monitor would allow Bree to take pictures and videos of W if John would allow it. Brianna experienced multiple DV issues with her short relationship with John. Early in the pregnancy, on 9/11/23, when Brianna flew to Florida to try to work things out with John, he her in the face while driving her to the airport, and at the end of the trip, which she reported to the police, the ER, and the OBGYN. Prior to that, John took Brianna's phone away during arguments to stop her from calling the police. He regularly spoke to her in the most disrespectful manner and has since admitted to this online. He did. The videos came out, and he said that he has grown and matured for that. He would never do that again, etc., etc., etc. You're going back almost 2 years, ma'am. Your client is still doing this shit today. Today. Let's see what it said. Hilarious, exposing Bree. Right. Had Brianna filed a DVRO in 425 for the abuse had endured in 2020 or 2023, it would have been labeled as retaliatory and strategic. The fact that there is no dueling DVRO for the court to litigate does not erase Brianna's history of abuse and endured from John and his testimony the same. Within the same hour, that many filings in this case were made, the pro-John, for lack of a better term, Discord subchannel immediately buys the documents and disseminates them to the same pro-John Reddit page, followed by the same pro-John T pages on TikTok, posting the documents all over the forum. This includes all filings that occurred after the 5/2/25 hearing date when one would imagine these random strangers online would have put this case to the back of their mind. After this quick dissemination of every filing in this case through John's various channels, he then immediately goes to TikTok Live and to Snapchat Stories to comment on and post about what is being posted. Again, John does not discourage his followers from doing this, but openly participates in the sequence of events by talking about the filings and the case alongside the followers. First of all, ma'am, how is John supposed to tell us what it is that we do? 1, 2. I mean, I've never got them. It's public record, public knowledge. We purchased them ourselves. So I don't know. And again, it's a case that we're interested in. It is not often you have a young man who fights for his son and goes to this extent. And again, your client, ma'am, all due respect, is crashing out every fucking day online. Log on to TikTok, log on to Kick. Watch your client for a while. The one who says that she's just kind of over it anyways, like it's just over it. It's one thing you won't hear John say. John's never over it. John has always said, I didn't want to be a full-time parent. I wanted 50-50. But if the other parent isn't willing or doesn't want to, I will. Oh yeah, for sure. Chloe, she'll respond. Okay, let me keep reading so we can get through this before midnight. John has now filed 2 DVRO requests based on the same premise. Allegedly bullying online of a public forum, John by another public figure. Wait, what? John has now filed 2 DVRO requests based on the same premise: alleged bullying online of a public figure, John, by another public figure, Brianna, on 5/3/24 and on 3/27/25 on a temporary basis. Judge Kitchens denied the first request entirely, and Judge, I was going to call her Judge B, Rashawn, I guess, did the same on the second request, lest the order not to abuse. Both bench officers have now asked the parties to brief similar First Amendment issues less than 1 year apart. This is all very telling as to what John is attempting to do here. Circumvent defamation suit requirements by filing this type of suit that belongs in civil court, disguised as a DVRO filed in family court. You think John would know that type of information? Who has, I'm not saying he's a dumb man, has absolutely no legal knowledge to my known. You think he's going to know that? And his attorney, who's as smart as a whip, does know that. But do you think she's going to put herself in a situation to where she's going to put it through if that's not the right place to go? Come on, ma'am. Come on, ma'am. No, ma'am. Why would John do this? Most importantly, he has done this for the custody advantage that he would receive under, it says article, he has to win on this for his request for DVRO. As a close second, he is doing this because the defamation standard in California is a high one when the dispute involves 2 public figures, and he could never meet the standard based on the allegations he has made. Of critical note, John would have to prove the allegations defamatory statements were false and made with actual malice, and opinions generally are not deemed defamatory unless they imply underlining factual assertions that are false. Oh, ma'am. Oh, ma'am, with all due respect. I have a feeling you haven't been on TikTok or Kick or anything. John would be able to prove those in a heartbeat. John would have no problem proving any of that. Absolutely any of it. Hi, KT. Yeah, it is. It's just legal tattletelling. Yeah. She really is. I think she saw Bree, she saw money, and didn't realize the extent of this case, or really just doesn't care what the outcome is. At this point, is just grasping at straws. Let me scoot this forward. Okay. Oh, yeah. Oh, John's attorney is going to have a blast, I swear. Okay, here's their argument. Or here's her argument. This shall be interesting. You can just keep doing your thing. You guys are at 104 taps already. You guys are amazing. Thank you so much. Although not absolute, the First Amendment's right to free speech is strong, especially when public figures are involved. It's Bree, ma'am. All due respect. But anyways, while narrowly tailored, non-disparaging orders are common in California custody cases, restrictions must be narrowly tailored to only cover speech that interferes with the custody order. In our marriage of Hartman, 2010, 185 Cal, orders enjoining the right to speak on a particular topic as disfavorable or presumptively invalid. In our marriage of Moliano, prior restraints on speech are very serious and the least tolerated restrictions of First Amendment rights. In the California Constitution is more protective of free speech rights than the U.S. Constitution. The California courts require extraordinary circumstance before a restraint can be imposed. Then it goes on. I hate reading case law. Wilson versus Supreme Court of Los Angeles, 1975. In the marriage of whatever that name is. Anyway, so constitutional rights under U.S. and California constitutions prohibits this court from restricting the parties' speech about one another online unless the speech is made in the presence of W or is detrimental of W's health, safety, or welfare. W is 15 months old and has never been to daycare or school. He cannot comprehend more than simple words. He cannot read. None of John's allegations against Brianna have anything to do with anything Brianna has posted or said about W or in the presence of W. The parties' opinions about one another that are posted online are protected speech. Now I want to go back up for a moment here, ma'am. Because all that blabbering you just did above. And then you go on and say this, which just flushes it out, in my opinion. The constitutional limits under U.S. and California Constitution prohibits this court from redirecting the parties' speech about one another online unless the speech is made in the presence of W. So, ma'am, doesn't that just throw out everything that you just said that you're claiming John did? He didn't, but you're claiming that he did. But then you want to say that it prohibits you from saying that. Then why are you even bringing up anything that he said? I'm so confused. You just threw out you just wasted our time. You just threw out. Or does that only apply to your client, ma'am? Because no, I know it applies to both. Ma'am. And listen, ma'am. Are you trying to say that because baby W, he's 15 months old, he has never been to daycare or school? Bitch, that's a blessing. That's a blessing. If you were in a position to where your child, especially one who's already had to have some medical stuff happen, they have a grandmother, an aunt, an uncle, whatever the case may be, to where they can stay home and build up their immune system and have, guess what? One-on-one educational time. He's not having to spend his time with 8 or 9 other kids, which is a blessing. Something that she would not be able to do. Coming from a grandma who's doing it her damn self. Okay? W is 15 months old and had never been to school. He cannot comprehend more than a simple words and cannot read. He's 15 months. Yeah, he's not going to read at 15 months. But to say, now again, my granddaughter, I know all kids are different. My granddaughter is exactly 1 month younger than baby W. To say that they can't comprehend words, bullshit. My granddaughter knows exactly what she wants, how to get it, how to say it, and how to specify it. She knows over 30 words. These kids are smart, especially when they're at home with their grandmothers all day. Right? Because we teach them. So if you think it's ma'am, your client's 25 and she can barely read. Okay? So I would like you to pop down. Absolutely. Yes, you were right, Nikki. My grandbaby knows it in English, sign language, and some Spanish. Exactly. She's only going off what Bree has said. And Bree, no, listen, when you only spend 10 hours a month with your child, you don't know. And the child's not even comfortable enough with you to do everything it is that they know. Okay, let me see here. That is irritating. You can't read. If you could read, you're a freaking genius. None of John's allegations against Brianna have anything to do with anything Brianna has posted or said about W in the presence of Winter. The parties' opinions about one another that are posted online are protected speech. Then why'd you just bring up 5 pages bringing up what John said? Nonetheless, A, the court cannot limit the parties' speech about each other when the speech is not made in the presence of W. She has no direct effect on W, including speech that may cause strangers to the parties think poorly of the parents. Oh my god. This dumb ice. Literally, Maisie's. I'm like, didn't she just spend 5 pages? I know exactly. Didn't she spend 5 pages talking about how poorly he talks of, that John talks of Bree and blah, 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 and how about this? And now she's claiming that the court cannot control what it is they say. They can say, they just can't say it in front of W. Literally a Timu lawyer. I am kerfuzzle buckled. And this is the thing. Granted, yeah, he's 15 months now, but guess what, ma'am? Kids grow up, and eventually he's going to grow up. Literally, not enough. I was just looking for a second once this one's almost empty. I'm going to need it. I don't know. We'll talk about that after this. I don't care. I am literally shocked right now. I don't know why. I would love to be a fly on the wall in that courthouse, because I tell you, the way his attorney, flabbergasted, the way his attorney is going to read into this. Okay, so then it goes into, she states, Natasha, thank you for the hearts, love. She states case law. I don't like to read case law, but appellate court ruled that a custody order limiting ex-wife from disclosing negative information about the former husband's new wife to anyone except specific professionals was an unconstitutional prior restraint. I don't care about that. I want to know about, this is still just going on into case law to prove that she can say anything she wants to. I have no idea. Don't even know how she passed the bar. I really don't. I don't know what year she passed it. I am flabbergasted. Husband and new wife argued what John is attempting to argue here, that the order was constitutional because it created limited restraints while still protecting the children from the harm, and that the information could be used by ex-wife as harms. This is all case law. The court overruled this argument, concluding, okay, again, I don't want to know about case law. Okay. As noted earlier, John is attempting to circumvent the high legal standard attachment to the defamation lawsuit between public figures by filing his claims as a DVRO. He is not just doing this because he could never satisfy the element of a defamation suit, but for the custody order advantages that come with a win on a DVRO case under FC 3044, as the Candioti court ruled. Rude and unkind comments made by one parent about another parent outside of the presence of W could be libelous, but since they were not made around him and were not detrimental to him, the court cannot make orders to prohibit them. John may argue something like that. Now she's guessing what John may or may not argue when it comes up to it. What is happening in this? This lady is really, God bless America. So it says John may argue something like that. W will be in school and part of the rumor mill eventually and will be able to read someday, to attempt to draw next. That's exactly right, as he should, because that's right, ma'am. Knock, 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 ma'am. Is anybody fucking home? It should have been, Miss F. Thank you, love. Miss F, are you listening? Miss F, am I boring you? Because, ma'am, the judge said herself, not only about this case, but about any time she can get in front of somebody young or young parents, whatever. She always likes to tell them this: the internet is forever. And they may be babies now, but one day they are going to grow up, and that day is going to come a lot sooner than what you think. And what they're going to do is they're going to be able to go on and type in their information, and they're going to be able to say, damn, Dad said this about my mom. Mom said this about my dad. Like, why was Mom doing this? Why was Dad doing that? So just keep it off of the internet, right? So that's what the judge in this case says, ma'am. So for you then to type up in your little thing and says, well, John may take it as, well, they said this or they said that. All undue disrespect, ma'am. Have several seats. This woman, I tell you. You think so? You think? As he should, because he's a good dad. He should be concerned about what on earth his son may see. And you know what his son's going to see when he Googles him? How he protected him. How he even protected his mother. Yeah. When people were trying to get him to talk shit about his mom and do stuff. No, he says, I'm not going to do that. I'm not going to talk down on his mother. I wouldn't do that. You picked the wrong guy. Oh, give Brie a chance. You don't have to give her a chance. She just wakes up talking shit and spewing shit about him. All right, let me continue. Sorry, I got on my high horse right there for a second, because that is just absolutely disgusting. Let me see, where was I at? Okay, here we go. John may argue something like that. Okay. W is 15 months old, not yet in daycare or school. From what Brianna can deduce, what does that mean? From the little information John shares, W spends most of his time alone at John's mom's house, meaning he and John are not socializing with other children or parents in situations where the rumor mill argument would even apply. More importantly, if this was John's argument, the court should want to know his response to how Winter would feel someday, seeing that John has posted about Brianna during her pregnancy and Jesus Christ, this lady. I don't know. I know she said she's going to be busy this summer, but hopefully she'll come back. During the pregnancy and the pendency of this case, she is a whore, a prostitute, an escort, a deadbeat. She has no relationships with any of her immediate family, and countless other horrific comments making fun of her looks. Even a comparison of her baby pictures with W's baby pictures could convince someone they are twins. Where was the lie? First of all, I've never heard John say any of those things. Well, I have. I've said them. I say them. John has not said them. But even if so, she's a whore. 10 men, 8 months, 4 in a weekend, 2 in one night, got pregnant, didn't know who the baby's dad, just saying, a prostitute. Well, she admits herself, she just calls it a different word. She goes out on private jets and goes out with all these rich men, and she gets paid for, so, bags. An escort, again, same thing. She's flying around, she gets picked up and paid to be an escort. A Debbie, she's not around. She's not with the child. She's doing the bare minimum. Has no relationship with her immediate family. She said that. She has said that. We never see her with anyone. Her mom periodically. You, ma'am, even stayed in here on the rare occurrence that they were together for Mother's Day. They want to take on that rare occurrence because she was in Texas. Bree goes to Texas every month to see baby W. Why was that a rare occurrence? Should be every month. And countless of other horrific comments making fun of her looks. No, I've never heard him say anything about her looks. When comparison of her baby pics with W's baby pictures could convince someone the two were twins. Okay, what's negative about that? The court has no ability to restrain speech made by the parties about one another. This is not made in the presence of winner or detrimental to him. B. In the DVRO context, the court cannot restrict the parties from posting about the case or each other on social media. Although Maliano discussed below was initially not certified for publications, it was later decided that certain parts would be certified for publication, with the exceptions of part 1, 2, 4, and 5 for discussion. In RE, Marriage of Melania, we're going more into case dates. Literally. In the DV context, the appellate court struck down a sweeping prohibition against posting anything about a divorce case on Facebook, finding this restriction to be overboard. What does this have to do with anything? I'm not going to read through the DVRO, through the case law, guys. That's just, no. I'll read at the end what it says, how it puts this case together with the other one, but I'm not reading case law. Okay, C. This case is distinguishable from the holding in People versus Nixon as to the applicable law standard context on the online post and timing context. Again, it goes into the case law. If John says that about Bree, he's saying that about... Oh. Well, he also put John's picture next to baby W and they look like twins. And she calls John ugly all the time. All of the time.